Now, there has been both jubilation and shock as different sets of the Kenyan society digest the court ruling allowing the registration of a gay rights body.
A three-judge bench of the High Court last Friday ruled that the National Gay and Lesbian Human Rights Commission be registered as a non-governmental organization as per the Constitution.
KTN's Catherine Omando explored this landmark ruling in our reports.
There's some people who would think in a very pedestrian.
Funjeri Gatero, as the legal advisor of the National Gay, Lesbian and Intersex Human Rights Commission, Friday's landmark ruling is a win for her commission and the group of Kenyans she aims to protect.
We were denied registration for about 3 years, since 2012. And I think late 2013 we went to court to ask the court to interpret to us whether we were as LGBTIQ identifying or LGBTIQ organizing persons, whether we were allowed to register an organization as within the stipulations of the Constitution of Kenya.
While the ruling is perhaps the bravest ruling since the promulgation of the new Constitution, it is a ruling that lawyer Harrison Kenyan believes should be reversed.
And now the court says that no, it's acceptable. You can be a homosexual and you can be a lesbian and not be discriminated against. In other words, you can come out in the open now. It's clear and you are protected.
I don't think that is true. We, as an organization, formed the organization because there was a clear need between the people who already identified as queer, lesbian, bisexual, intersex and transgender people. It was a need that was already there, meaning that there's already a constituency that is desiring of our services, you see, and our services are just to provide legal aid and to provide advocacy and also to document the violations against persons who identify as sexual or gender non-conforming.
According to the officials of the new commission, this legal advice will not be limited to gay men and lesbians,
nilizaliwa nikiwa na maumbile mbili,
but also to the intersex group, as well as people like Audrey Mbugwa, who believe that they are of a different gender than that which they were born. Both cases go beyond personal choice and preference and are actually considered medical.
Homosexual sexual conduct still remains illegal, and that hasn't changed yet. But then it's so uplifting for us to see that the court is very conscious of the differences within the people who make up the Kenyan society.
While Harrison believes that the ruling should have been made based on religion, the court thought it best to do otherwise.
If 3 judges can sit and decide on behalf of the majority of the people of the Kenyan inclination against homosexuality, saying that no, you ought not to bring your biblical and Quranic views about homosexuality, we say it is not the law. They have said it actually in the decision, which is here in paragraph 106. Your Bible in your Quran does not count. If that is the basis of your objection, sorry, we have refused.
I wish to just remind the judiciary that we're the ones who make the laws of this country. And their job is to interpret the clauses of that law. But when they interpret those clauses wrongly, then the onus is on us to clearly and make it probably word by word of what it is that we mean.
There is a general assumption that it is the words gay and lesbian in the commission's title that is irking those against the registration. The NGO board had originally refused to register the commission. Their argument was that in the penal code, homosexuality is illegal. However, according to the Bill of Rights, every Kenyan has a right to be legally represented and has the right to be protected from violence. Religious leaders and anti-gay lawyers intend to appeal this ruling. Catherine Omwando, KTN.